Well, thanks to all of you for coming out on a Friday afternoon. This is a conversation about church and state relations, sponsored by the Federal Society and the Duke Bar Association. We're very thankful to them. It's a great pleasure to me to be able to introduce both my pastor and my mentor. It's neat to have them on the same panel today. So Sam Wells is the Dean of Duke University Chapel, and if you want to see him really in action, just walk over on a Sunday and listen to the sermon. He is also the research professor of Christian ethics at Duke Divinity School and a leading theologian. Sam was educated in the United Kingdom and did much of his early career there, and so offers a somewhat different perspective from a different legal system with a different constitutional tradition on these matters of church and state. He will be interviewing Doug Laycock, who is the Yale Camisar Collegiate Professor of Law at the University of Michigan, but up until a couple of years ago, he was at the University of Texas, where he taught me everything I know about being a law professor. And so those of you who are on the receiving end of that can file your complaints with him. Doug is probably the leading scholar in the country on the law of church and state, as well as the leading scholar in the country on the law of remedies. And so we are very well privileged to have both these figures here to talk about church and state. We will talk for about an hour. Probably the last 15 minutes of that we'll open up for questions from the floor. So enjoy.
Thank you. I'm going to ask a few questions to Doug. I'm going to start with some historical questions, because for me this is a journey into the unknown. And because my undergraduate degree was in history, that tends to be the way that I begin to try to understand a new subject, is to try and get some historical perspective on it. I know one church historian of the United States talks about the way the dissidents in Europe fled religious persecution in Europe, only to come to this new and promised land, only to inflict such religious persecution on anybody they could find to inflict it on when they got here. Would that be a reasonable rendering of the, shall we say, pre-revolutionary period in church history, from your point of view?
Well, it's an overgeneralization, but basically, yes. The Puritan view was that everyone else had the liberty to go anywhere in the world outside Massachusetts, and that was quite enough liberty for them. But some of the other colonies did better. The Quakers did not persecute anyone in Pennsylvania. They were quite open. The Catholics controlled Maryland for 40 years in relative peace. They let in some Anglicans, and that turned out to be a mistake. There was an Anglican coup in 1689. They took over Maryland. New York under the Dutch had remarkable religious diversity and religious freedom in the mid-17th century, way ahead of everybody else. The record is mixed, but yes, there were plenty of people who wanted religious liberty for themselves and only for themselves. I call that the Puritan mistake, and we're not entirely innocent of it today.
My understanding, and please correct this historical understanding, or also certainly nuance it, as you've just done the previous observation, that there are broadly two strands in American religious history. There's the strand that regards the Bible as the Constitution, and the strand that regards the Constitution as the Bible. Would that be a fair observation?
This is live and unrehearsed. I don't know the questions. He didn't know the answers, and sometimes I don't know the answers either. There are probably more than two, but yes, certainly those two are easy to find.
And there, I mean, as I would trace them, the first one goes back to the kind of Massachusetts that you've described, and still surfaces today in the religious right, in the assumption that putting the Ten Commandments on the wall of a courthouse is well, is possibly defensible in terms of natural law and historical origins, but in fact is desirable because presumably it will make people better.
Yep.
And more, probably more Christian, or certainly more theistic and more ethical and more moral. And then the second one, it seems to be alive in the sense that the American Constitution attracts to itself a kind of loyalty and a kind of optimism that actually pretty well all disputes and tensions in human relations can be resolved through the law courts or through legislation.
Well, I think that's part of it, but part of it is that's what unifies this nation. This is a nation without a nationality. The population came from all over the world. It's a nation without a royal family. It's a nation without a common religion. So what holds Americans together is an idea, and the single most visible embodiment of that idea is the Constitution. Now, lots of people love it and couldn't tell you a thing that's in it, but it has served a sort of national unifying role that takes the place of some of these other unities that unify other nations that we don't have.
And does that account for, certainly as a foreigner in this country, they're very happy to be here. One of the things that strikes me when people talk about the Constitution, and certainly when people talk about the First Amendment, but usually in relation to constitutional issues, and clearly, enhanced by the era of terrorism, if one might call the last 10 years, is this sense of almost perpetual crisis that American freedoms are something that are always just 24 hours from being snatched away. And I, having lived obviously outside this country, that seems a particular feature of public discourse in this country, not often on a popular level. But I don't know whether that sense is historically derivable, or if that is manipulated because it somehow appeals to a popular imagination that serves particular political ends. But I'm constantly amazed that in general public conversation, this sense that we inhabit freedoms which some usually unnamed mystery party elsewhere is about to snatch away from us is almost normal discourse. Can you tell me more about how that comes to be the case?
Well, it's not some unnamed party, it's the other party, right?
It's the other, yeah.
The Republicans are chronically about to snatch away all good liberal rights, and the Dems are constantly about to snatch away all good conservative rights. It was one of your Queen's Irish subjects who said eternal vigilance is the price of liberty, and Americans picked that up. I think, from the founding, Americans had a much more suspicious view of the state than most Europeans, and the rhetoric and the political theory of the founding is all power will be abused, and so you have to separate powers, you have to have checks and balances, you have to have a Bill of Rights, you have to have an independent judiciary to enforce things, you have to then try to figure out a way to have a check on the judiciary. You can't trust anybody. Power corrupts, and power will be abused, and that tradition has continued, and maybe to some extent it's deep in the American character, but I think it's also the case that at nearly any point in time it will be in someone's political interest to agitate those issues, and so we keep being reminded of it. And to some extent reality vindicates it, right? Governments screw up, and power does get abused. But on the whole, the the liberty issues we fight about in this country is certainly true of religious liberty and largely true of the other constitutional rights, are out around the perimeter, right? They are the disputable applications, but we've had relatively little of violations at the core. Right? We don't have political parties banned. We don't have churches suppressed. We have very serious arguments about things that matter deeply to people, but we've managed to avoid most of the worst abuses that go on in other parts of the world.
Well, I think that's the thing that strikes me. I mean, from a Western European perspective, Spain, Italy, Germany have lived under dictatorships in living memory. In the case of Spain, up until really quite recently. And America hasn't, and yet you get this crisis discourse in America in a way that you don't, as I understand it, in those three countries.
Yeah, I think that's right.
So there's no further explanation other than that it's
if you put up guards to keep the elephants away, they stay away.
Vigilance.
Right?
Can I push you on one more historical question to which I suspect there isn't a right answer. It's simply a matter of opinion, because there isn't a control experiment on American history. But when the word separation is used, as it's used, constantly in these questions, from time to time it's pointed out that separation was or has been the key blessing to religious bodies that provides a very significant explanation why, when Western European practice of religion has lapsed into quietude, that has not, quite the contrary, has been the case in this country. Almost that the free enterprise of religion has made religion flourish in America in a way that it's sometimes suggested that the yoking of religion to the state in some Western countries has proved its downfall. Do you see that as a plausible reading of history, or something that has an element of truth but doesn't quite do justice to the diversity of American religious history?
I think it's highly plausible. I think most religious liberty scholars believe it. Now, we're not sociologists or historians, and the fact that we believe it doesn't necessarily make it true. But there are a number of causal mechanisms that are fairly easy to envision, and some of some of this explanation goes back to the founding and before. If you are a pastor, I don't want to get personal here, but if you are a pastor and if you are guaranteed a salary by the state, no matter what you do or who shows up, why should you try very hard? Right? You don't have to really care. You got a guaranteed income. And if you read the portrayals of the Anglican clergy in 19th century English novels, Dickens or Jane Austen or the Bronte sisters, the only thing about the clergy is how big is their living, and are they worth marrying or not, right? Do they have 35 pounds a year or 100 pounds a year? Whereas if you got to compete for a congregation, and if your flock isn't happy with you, they'll go down the street and hear somebody else, well, then you've got a lot more motivation to be energetic and be successful. I think that's the most obvious mechanism. Dean Kelly, who was a Methodist pastor and the point man on religious liberty for 25 years at the National Council of Churches, back when the National Council of Churches mattered a lot more than it does now, he had another take, which is government-sponsored religion inherently can't perform the functions of religion, because religion has many functions, but at least one of them is to console the oppressed and the downtrodden. And it's often government that's doing the oppressing and the downtrodden. So government-sponsored religion is a contradiction in terms. And there's probably something to that. I think the first explanation does more. You know, one other thing that's been pointed out, and this isn't true of all of Europe, but it's true of much of Europe. In America, the churches were on the right side of the revolution. And in much of Europe, they were on the wrong side. You know, the Catholic Church in particular resisted democracy well into the 19th century. And it left the people with a very different view of religion than what they were left with here.
I mean, I'm supposed to be asking the questions here, but I get to give some of the answers as well.
Of course.
My view on that is that the degree to which in England the church is tied to the state is hugely exaggerated in these kinds of conversations. That's certainly not what any Church of England vicar or rector thinks they're doing that I've ever met. However, the latter point that you made, to me, the most significant difference in Christianity in this country, certainly in Protestantism in this country compared to Britain, is that its permeation of the working classes is in England. The Church of England's experience of Christianity is largely something that belongs to the middle class and is offered to the working class who freely reject it. Whereas here, the great divisions, it seems to me, are about whether your pastor has been to seminary or not. That's where the class lines seem to fall. Whereas the notion of someone having the free enterprise to set up a church if they haven't been to seminary is almost unknown in the UK. It just doesn't really happen. I'd like to just start the next question with a reflection on my own experience. I preside here at Duke, for those of you who don't know, over something like 25 different religious life groups, round about 18 of which are Protestant, because we have wonderfully diverse ways of being Protestant in this country, but only one way, apparently, of being Jewish or of being Muslim or of being Buddhist, which is not, of course, true, but that's the way it's represented here on the campus. And that, I think, has an effect, as I understand it, on the constitutional understanding of religion in America. Because I sometimes tease my colleagues on the religious life staff and say, you're very, very welcome here, so long as you're a Protestant Buddhist, or a Protestant Muslim, or a Protestant Catholic. Because the assumption is that the definition of religion that's at work is really a Protestant one. That's to say that, and it's not just a Protestant one, it's a post-Enlightenment Protestant one, in which God is fundamentally something that I discover within my own heart, and that I choose to express how I see fit, and therefore, provided I do it within certain quite strict hospitable and polite parameters, there is no logical reason why it really has to affect anybody other than me. That's what I mean by we're all Protestants, really. Now, it may be that in Catholic theology and in the Muslim view of the world, that sort of description is absurd. But everyone on the religious life staff knows the rules, that you actually have to be a Protestant if you're going to operate in religious life, because all the rules are set by Protestants, and they're all set by Protestants who assume that religion is fundamentally an internal matter, and that it's purchased on external reality, uncertain, and particularly on social organisation, which of course is so important for Catholics. Is really a secondary matter. And so we create a word like spiritual, which is a way of saying that that our religious beliefs matter enormously to us, but have no effect whatsoever on anything else. And that's what I take spiritual to mean in public discourse. Would it be fair to say that the way the word religion is used in much of the constitutional debate would meet that broad, what I would call that post-Enlightenment Protestant description?
That or something pretty close to that. I think the sense that religion is in your heart and you look internally to find it is fairly recent, actually. But the notion that it's a matter of individual decision is very old in Protestantism and very old in American religion, and reflected in the rhetoric the Supreme Court uses to talk about religious liberty. So, once Protestants began to teach that the Scriptures were the sole authority and that every human could read the Scriptures for himself, then there was no limit to splintering, right? Anybody who came up with a new reading and had enough initiative or charisma to attract a few followers could start a new church. And it happened less in Europe, and probably for social reasons and partly because they retained the established church. But it certainly happened in America, both in colonial times and national times. And the reason that that religious liberty was such a big issue at the time of the founding was that, 30 years before, 40 years before, the Great Awakening had caused this enormous growth in the dissenting churches. And so the Anglicans, who were established in the South, and the Congregationalists, who were really the descendants of the Puritans and were established in New England, they were no longer nearly so politically dominant, and they had surging minorities of Baptists and Presbyterians we don't think of as evangelical today, but were certainly evangelical in those days. And the Methodists came along a little later, and so they were in smaller numbers at the founding, but they were growing very rapidly too. And it was evangelicals who put this on the agenda and who insisted on free exercise and disestablishment in the new state constitutions and in the federal constitution, and that process of continually breaking off just continued. So you had Northern Baptist and Southern Baptist and Free Will Baptist and Hardshell Baptist and Progressive Baptist and Traditional Baptist, and now we've got all these non-denominational Christian churches. When I was a kid, there was somebody claimed to have counted, and there were 453 denominations in America. It was probably a phony number then, but I'm sure it'd probably be a much bigger number now. So the Supreme Court's theory of religious liberty is every individual has the right to choose for himself. And they don't put it in terms of read the Scriptures for yourself or look into your heart for yourself, but it's an individual decision. Decide what you believe, decide what you think is true. And that rhetoric has a very long history in America. You find it in 18th century sermons, and you find it in political debate about religious liberty. And I know there are Catholics, I assume there are Muslims and Jews, who find it very alienating. Marianne Glendon at Harvard, who is a serious Catholic, and was our ambassador to the Vatican for a while during the Bush administration, says, we don't experience religion as something we chose. We experience religion as something we inherited. We were born Catholic, and we were born with this obligation to the church. Now, I suppose you can always say, she's making an individual choice to adhere to that. She could choose to walk away, and lots of Catholics do. But this rhetoric of individual choice fits Protestantism much better than it fits other traditions. There's no doubt about that.
And in your work, you tell a fascinating story about how originally we had debates between Protestants, and then we had debates between Protestants and Catholics, and then we had debates between conservatives and secularists, broadly speaking. But what that story doesn't include is debates between Christianity and other faiths. And in some ways, that's been that debate, which obviously with a greater diversity of population is enhanced in America, and certainly on a college campus like this is very significant, but can be collapsed under the conservative secular debate. But in fact, it's a rich debate of its own, and isn't the same debate at all. So, for example, what is a Buddhist who may not have a particular interest in the notion of an identifiable being called God, and yet would be recognized by most persons as being a person of faith or a religious person? to make of phrases like one nation under God.
Right. You know, we have always had issues about the proper treatment of non-Jewish, non-Christian minorities and now non-Jewish, non-Christian minorities. And you know, in that bit of history you described, I didn't mean to exclude or diminish those, but those have never been the dominant line of conflict. Right? Because the numbers were never big enough. The dominant line of conflict was Protestant in the 18th century, Protestant Catholic in the 19th and early 20th, and religious secular now. But plainly, there is a problem at the grassroots with ordinary Americans in assimilating Muslims and the Asian religions, Hindus and Buddhists, and then the large number of, you know, very small, lesser-known religions that come to us from all over the world. You know, Santeria and Animist and Hmong and all these other flows of immigrants. And you know, I think you know, the Jewish community is clearly in. They're accepted. They're part of the governing coalition. But all these other groups are still struggling for acceptance, and it takes a long time for that to happen, especially at the grassroots.
But,
So they're legally protected, but they may have trouble enforcing that. They may be socially discriminated against. They may have political problems.
But there isn't, I'm not hearing you saying it's time for a rethink of the definition of religion, or to accommodate, you know, a non-specifically or non-generically Protestant default.
You know, I try to be careful and talk about protecting religious choices or commitments to take account of the Marianne Glendon critique, and I think it would help if the Supreme Court would talk that way too. But the judicial understanding of what counts as religion is capacious enough to include all these groups and give them legal protection without much difficulty. I mean, the place where we have difficulty conceptually is with non-believers, who, of course, are a rapidly growing group today.
Again, I guess what I'm pushing at, particularly in terms of the previous question, the assumption that religion is essentially an individual, internal thing, is that for the person who, shall we say, regards preventing other people from having abortions as a religious duty, because they haven't derived that from anywhere else, they've just derived that from, you know, from their own faith tradition, and for the person that might feel, again, perhaps from religious commitments, perhaps less easily specifically identified, that, shall we say, a gay person should not be teaching their child in school or something of this kind. Those might be sincerely held by the person themselves as religious, as expressions of their religious faith, but constitutionally they wouldn't be regarded as free expressions of religious faith. Am I right? Because they don't meet the definition that religion is fundamentally about an internal conversation between oneself and the divine, or something of that kind.
No, I don't think that's the problem. I think you know, I don't think judges have any difficulty dealing with somebody who says, you know, my religion is not individual, it's communal, and there are rules, and God makes them, and my pastor tells me what they are, and I just follow them. Actually, judges find that the easiest religion to deal with. They don't worry so much about insincere claims and so forth. So this talk about individualism is more in the culture than in the law, and in the law it is more rhetoric than rule. You know, so other forms of religious faith can be recognized. Now, the two examples you offer may wind up not being protected, but not because they aren't religiously derived. And I don't think judges have any difficulty in understanding that for many people, opposition to abortion is religious. And you know, and obviously we don't have compulsory abortion in this country. It's hard to imagine a hypothetical where someone would be resisting an abortion for herself because of religion, but if you could imagine such a case, she'd be protected on privacy grounds anyway, but I think she'd also be protected on free exercise grounds. But she cannot have a religious right to prevent somebody else from having an abortion because our rights to free exercise of religion have to exist for all of us and have to exist equally for all of us. And so there simply can't be a right to impose your religious views on somebody else, even though, no doubt some people believe it's their religious duty to do that. But we can't give A a right to impose religion on B as a matter of A's free exercise without depriving B of free exercise. So the claim that I have a religious duty to stop others from abortion is not going to prevail. And actually the cases that come close to testing this are the abortion protest cases, right? Where there's clearly a free speech right to gather around the clinics and to chant and hold up signs, but there's not a right to interfere with access and keep people from going inside or shut the clinic down. The person who doesn't want to be taught by a gay, doesn't want their child taught by a gay teacher, may actually be able to work out an informal transfer, but where that doesn't happen, I think there's no good reason why you couldn't give that person a right to transfer, but I think most judges would be pretty nervous about that claim, and they might find a compelling interest that isn't really all that compelling to say you don't get to dictate personnel assignments to the school or something. I think, the problem with protecting the free exercise of religion judicially is not that judges can't recognize a broad diversity of religions. They don't have a whole lot of trouble with that. The problem is they get nervous very quickly about countervailing interest. They worry about the floodgates. They worry about a whole series of phony claims. If I grant this one, what's going to be next? They worry about the worst possible hypothetical, and then they lose their nerve and they stop. And I'll give you just one example of that. I argued a case in the 11th Circuit and then again in the Supreme Court of Florida that a generation ago could not have arisen, should have been a no-brainer. The city of Boca Raton wanted to remove all the crosses, all the Stars of David, all the statues of saints from the city cemetery, including from existing graves that had been there for years and years, right? Because they had a rule that there weren't supposed to be vertical markers, although they never enforced it, and it actually hadn't said that until they amended it quite recently. And because, I'm not making this up, their compelling interest was, it's easier to mow the grass if we can just drive a riding lawnmower over everything, all right? So what do I get asked about at our argument in the 11th Circuit? What if somebody wants to bury their family member in their front yard and build a 200-foot obelisk over the grave, right? Would you have a free exercise right to do that? And the clear implication is, if you can't do that, why should you be able to do this? Because I'm just a judge, I can't draw lines, right? That's why we have trouble protecting free exercise in this country, and not because judges can't recognize religion, although actually there were expert witnesses who said that none of these things on the grave sites were religious either, but that was less persuasive. We eventually lost that case.
One more philosophical point, and I wonder if you might be able to explore this in a descriptive way. One of the things I've found about your work that I've most helpful philosophically is the way you talk about the tensions between neutrality and liberty, and whether it's possible to have both in the end. And I wonder if you could maybe explain that a little bit more, and also reflect philosophically on whether neutrality is a sustainable concept.
Well, certainly there's lots of scholarship that says neutrality is a meaningless idea and impossible to achieve and so forth, and maybe it's a matter of how perfectionist you are. I think we can, certainly can't be perfectly neutral with an institution as big as government. But it's a very widespread intuition that the religion clauses require government to be neutral towards religion. an established church is government-sponsored, government-supported. Turns out there's some disadvantages for the established church that come in the wake of that, but the core idea is the government-sponsored, supported church is established, and when we say no establishment of religion. And we say no prohibition of free exercise. So one clause looks like don't support religion, the other clause looks like don't interfere with religion. That sounds like a formula for neutrality, and the Supreme Court, which says lots of different things, has said that thing fairly often, but not all the time. And certainly lots of people have that intuition. It's also a pretty straightforward intuition that the free exercise of religion includes the right to actually practice your faith and do the things it motivates, and not merely to believe. I mean, Oliver Cromwell said to the Catholics of Ireland, I meddle with no man's conscience, but if by freedom of conscience you mean liberty to say the Mass, you don't get to say the Mass, you only get to believe it. Right? Well, that's not a very sensible concept of religious liberty. So you start with this intuition, people ought to be able to practice their religion. And then, well, what if there are laws that for some reason make a religion illegal or a particular practice illegal? If we have a law that bans Catholicism, that's easy. That's 9-0 in the Supreme Court. If you have a law that says you can't give wine to children no matter what, well, that's not so easy. That looks like a neutral law that was written for general purposes, has nothing in particular to do with Catholicism, but First Communion just became a felony. Right? So it seems pretty straightforward. We'll give them an exemption. They're not hurting the kids, right? Just tell them the law about alcohol in kids doesn't apply in church, or at least doesn't apply in church with reasonable quantities. Right? Purim, the quantities get a little bigger, as I understand it. But, different religious traditions. So those are two pretty strong intuitions, and then folks on the secular side said, but wait a minute, these exemptions are not consistent with neutrality. These exemptions are special treatment for religion, right? If you tell Catholics and give communion wine to kids, if you tell Quakers they don't have to serve in the military, to take a more serious example, that's not neutrality, that's special privilege, that's special treatment. And so these two intuitions are inconsistent, and you got to choose. And of course, for the people making this objection, it was no brainer. They chose neutrality rather than liberty, and proposed a rule of no exemptions. Well, yeah, but surely liberty is at the heart of the two religious liberty clauses. So one of the things I tried to do was think about how do you reconcile these two intuitions? Is there a coherent understanding of neutrality that is consistent with liberty? It's consistent with exempting religious practice except when there's a sufficient government reason to override the interest in religious liberty. And I think there is. I didn't just make it up. I made up a label for it, but you find it in the Supreme Court's cases. Unfortunately, the label I made up was substantive neutrality, and I think a better label would have been incentive neutrality. But the core idea is what it means for government to be neutral towards religion is to create no incentives for people to become more religious or less religious. Now, government has the power to throw people in jail, and it spends 3/8 of GDP, and so it is like the elephant in the room, and it's hard for it to have no influence on people. But so it has to become a standard of minimize the government's effects on people's incentives. And in the communion case, that's very easy, right? If we say giving communion wine to children is a felony and the priest who does it goes to jail, that's a powerful disincentive. If we say, communion wine is exempt from the alcohol laws, do what you want, that doesn't encourage anybody else to become a Christian or change to a denomination that uses real wine or go to communion more often, right? It's a totally meaningless activity unless you already have the religious belief that gives meaning to it. So the exemption is neutral in terms of its effect on incentives, and that is true across a very wide range of religious conduct. It's not always true, right? If you decide you object to war in any form, you get out of going to the draft and you don't have to go to Iraq, people might find that a powerful incentive to join one of those peace-loving churches because they don't want to go to Iraq. And so when religious belief aligns too closely with secular self-interest, the government has to make restrictions. What we do in the military case is require alternative service. Sometimes you just have to say we deny the exemption, right? If I create a new religion that said it's a sin to pay taxes, boy, would that grow in a hurry. But the courts obviously couldn't allow exemptions for that. So exemptions are not always neutral, but I think across a very wide range of cases, exemptions are substantively neutral. They don't change people's incentives because people don't want to keep a kosher diet or stay home all day on the Sabbath unless they are religiously motivated already to do that.
Well, thank you. We've talked a little bit about the history and the philosophy. I just want to toss you a few of the dilemmas, the quandaries, and then after I've done that, I'm going to ask if there are people in the audience who would like to do the same or go further on any of the other issues. One part of American history that fascinates me that I haven't read much about in relation to the church and state questions is when the Mormons stopped being encouraged to live polygamous lives, or certain Mormons. I could probably express that better. I've never understood why that restriction of liberty was considered something that the state had a stake in.
Well, that was a 19th century dispute. It was a different time. Notion the circle of tolerance was much less inclusive, and the court was having none of the Mormon claim to polygamy as a matter of free exercise. The Mormons were enormously unpopular, and not just because of polygamy. They were unpopular in Missouri because they were anti-slavery. They were unpopular everywhere they went because they tended to live in large colonies and buy up big chunks of land and become economically and politically dominant. So they run out of one state after another. And when they went to Utah in 1847, it still belonged to Mexico, and that changed the next year. But polygamy was deeply offensive to the dominant American sense of morality, and that was all the justification was needed. And it might be all the justification is needed today, but it was certainly all the justification was needed in 1879 when the Supreme Court decided the issue. And the opinion, there are people, there are plenty of respectable lawyers who think the case was rightly decided. But whatever you think about the result, the opinion is an embarrassment. The opinion talks about how, polygamy is a feature of African and Asian peoples, and before the Mormons, it was never known among Western peoples, and it leads always to despotism, and it's just one negative generalization after another, and the steps that the government took to end polygamy were really quite extraordinary. They started by regulating this domestic matter that would normally have been left to the territorial legislature, regulating in Congress. Then they took away the spousal privilege so they could force wives to testify against their husbands. They enacted an irrebuttable presumption that if you lived in the same house, you were married. So they didn't have to prove either the marriage or the sexual relationship. They brought 3,000 prosecutions. Then they dissolved the church's corporate existence and seized all its property except for actual places of worship. They barred Mormons from voting in at least the Idaho Territory, and I assume some of the other places. Supreme Court upheld that. And the prophet got a new revelation right after the seizure of all the property was upheld. And I heard some snickers. Maybe he really did. Maybe it was convenient. I don't purport to judge, but he got a new revelation, and it wasn't practical to practice the polygamy teaching anymore, and they abandon it. I've got a good friend at Brigham Young who says, I'm glad the church gave up polygamy. I'm glad they didn't give it up too soon, because I'm descended from a third wife.
Tell me about one of the curiosities for me in this culture, and this probably isn't. I suspect you're going to say this isn't essentially a constitutional matter, but I think you're better placed to comment on this than almost anybody else. Tell me about the Pledge of Allegiance. My children go to a public school in Durham, and when I was looking at the different places where they might go to school, I asked all the teachers in the public schools, tell me about the exercise of religion at this school, noting a lot of American flags in places where in Catholic schools there would probably be a cross, and noting that there was a pause for a solemn period that invoked the name of God and was focused in a particular direction every day. But that whenever I asked one of the principals of these different schools whether this was a religious exercise, there was astonishment that I could mean such a thing. Whereas I felt it, it looks like religion, it smells like religion, it probably is religion. Tell me about the Pledge of Allegiance and its place in American life.
Your children U.S. citizens or British subjects?
British.
Yeah. So before you even get to the religious part, right, we got no business asking them to pledge allegiance to the United States. And that problem arises, right? We had it with Mexican nationals in public schools in Austin. The pledge was proposed by a Protestant minister around 1890. So it's one generation after the Civil War. One nation indivisible may have been the most important point. There was also a period when the percentage of foreign-born was very high, a very high immigration rate in the 80s. And so it may partly have been about demanding repeated proclamations of loyalty from all these immigrants. As far as I'm aware, no other country in the world has anything like the Pledge of Allegiance. Under God was not in it. The phrase was one nation indivisible. Under God is added in 1954 at the height of the anti-communist battle, and it's proposed by a D.C. pastor in a sermon with President Eisenhower in attendance, and caught on like wildfire, ran through Congress in no time. Signing ceremony in the Rose Garden, they played Onward Christian Soldiers. And the reasons given in the congressional debate was this is to distinguish Christian America from godless communism, and remind the children every morning about their duties to God. They'll grow up to be better Christians and better citizens. So, there was no doubt it was religious. It was done for explicitly religious reasons, but it was very popular, and we all learned it that way. If you're under 60, you never said it any other way. Who was it? Justice Brennan, I think, who said things lose their religious significance through rote repetition. To some extent, that's happened, right? We just keep saying it and saying it. And so when Michael Newdow filed his lawsuit, and in, 2002, the Ninth Circuit said, under God and the Pledge of Allegiance unconstitutional, I guess you guys were seniors in high school or so then, but you probably noticed there was just a national firestorm. And we had 99 United States senators on the steps of the Capitol saying the Pledge of Allegiance and shouting out under God when they got to the under God part. The initial public opinion polls in the first couple of days showed support for the Ninth Circuit in double digits, 15-20%. That collapsed down to about 5% after people saw how everyone else felt and saw the reaction, and I think only 3% who said they felt strongly about it. Obviously, it was just pretty obvious the Supreme Court was not going to affirm. They had seen the political reaction. They weren't going to take that on. And they were able to duck on standing. Newdow has refiled his lawsuit. He recruited some new plaintiffs, and that's now pending in the Ninth Circuit again. I think we just lost the mic. It is one of those difficult things. I think it was impossible for the court to write a clean opinion upholding it, impossible politically for them to strike it down. I filed an amicus brief on behalf of 32 Christian and Jewish pastors that said, look, there are two possibilities here. Either the pledge means what it says, in which case we are asking children every morning to give a brief affirmation of faith, that there is a God, that the country is under that God. That eliminates some conceptions of God, includes a wide range of others, but eliminates some. Or the Bush administration is right, we don't mean it. Bush administration filed a brief that says this doesn't really mean the nation's under God. This is about historical and demographic facts that many Americans have believed the nation is under God, and that's all it means. I said, if we don't mean for them to mean what they say, then we're asking them to take the name of the Lord in vain every morning, right? That we're making this affirmation about God that we don't believe, we don't expect them to believe. And either way, government shouldn't be doing that. And that was the first two-thirds of the brief, and the last third was damage control. If you're going to uphold this anyway, here's the least damaging way to do it. And I actually got that into O'Connor's concurrence, but it'll disappear now that she's gone. Yeah, I think you're absolutely right, but most Americans don't have any sense of it either as religious or at least not as objectionable religious, right? Who could possibly disagree that the nation is under God? Well, a handful of atheists, and they don't count.
Well, just time for a little bit of interaction with your dynamic selves. Go ahead.
I have a question about liberty. You had spoken at length about the importance of liberty underlying the clause of the First Amendment. And I'm curious as to whose liberty it is, particularly in cases where parents have the right to decide for their children, their young children, to reject life-saving medical care on the grounds of religious liberty, where the child never has the chance for themselves to grow into a full human being to exercise their own liberty, and whether the parent should then be allowed to be exempt or immune from what would otherwise be a criminal prosecution for child abuse or neglect.
In my view, no. I mean, that's what the compelling interest test is all about, right? And keeping young children alive is a compelling interest, or saving them from permanent health damage is a compelling interest, if anything is. No judge has ever found a constitutional right of parents to withhold medical care from their children for religious reasons. There's a constitutional right of adults to refuse medical care for themselves. That's a very different question. No judge has ever found a right to exemption. But what has happened, and this is really quite astonishing, nearly all the states have, at congressional encouragement, have put exemptions for religious faith healing into the statutes on child abuse and neglect. And so parents are exempt by legislation, and it was a very effective bit of lobbying, mostly by the Christian Scientists, who are small in numbers, but middle class and well-connected and articulate. And I don't know where the College of Pediatricians was, but nobody showed up on the other side, and legislatures passed all these bills. And so then there are, every time a child dies, then we get a prosecution. And the state courts, for the most part, are saying, okay, you're exempt from the abuse and neglect laws, but you're not exempt from the manslaughter laws. If something goes seriously wrong, you're still guilty. And then the parents say, what? That's unfair surprise. Nobody told us that. It says right here we're exempt. Normally those convictions are upheld. But the litigation is all about statutory interpretation. It's not about free exercise, because no judge takes the free exercise claim seriously where a child's life is at stake. Now, there are other cases where the damage is either much lesser, or where it's a matter of value judgment whether there's any damage at all, where we do defer to the parents. So we defer to the parents on educational choices. You can send your kid to religious school or secular school or homeschool. The Amish at least can do homeschool that doesn't include the usual subjects and is on the farm. And some of those are controversial too. I think those are generally right. And the Supreme Court's view is the child is not the creature of the state, and the parents have the right and the duty to decide how to raise it. But the limit to that is something like the child abuse laws, and things that end in death clearly ought to qualify. And it's been a political judgment to the extent that they don't.
You opened the discussion to talk about, I guess, the positive benefit that the First Amendment has had on religion and kind of this free marketplace of religion, and that's why it's prospered in America. What do you think about some of the potential negative effects? What comes to mind is the prosperity gospel, which has exploded in recent years. And I have a friend in the divinity school, actually, who has, I guess, at least has a questionable attitude towards the prosperity gospel and thinks that it waters down some of traditional Christian theology. So how do you think that balance is played out with the First Amendment?
Well, I think the religion clauses. The question is, what about prosperity gospel? What about other religions we might think aren't so attractive? Are these costs of the First Amendment? Maybe so. I think the religion clauses are neutral on religion, right? And we're used to the idea that the free speech clause protects good speech and bad speech. And some pretty nasty stuff. Well, the religion clauses protect good religions and bad religions, including some stuff that I find pretty unattractive. And if you are, a more traditional Christian or Muslim that says, there's only one way to heaven and I've got it, then everybody else is wrong, right? Pius IX in the 19th century said liberty of conscience is the liberty of perdition. It's the liberty to let people make decisions that will get them in hell for all eternity. And maybe he was right. We'll find out. But I think when you commit, I think the fundamental decision is to get government out of the business of religion, because when government was trying to impose a uniform religion on everybody, the results were always bad. So you leave it to private choice and commitment, you'll get some good and some bad, but at least you got rid of the government coercion and you got rid of imposed uniformity.
In regards to imposing religion on others, you said that a woman may have a right to choose an abortion for herself, but doesn't have a right to impose that onto others. What about when that woman is a doctor and her choice to not perform an abortion could prevent another woman from getting
Right.
that abortion?
Abortion itself has not been terribly controversial on that issue. Congress passed conscience legislation back in the 90s for abortion after, in my view, a bad decision went the other way. That said a Catholic hospital had to do abortions or give up its residency in OBGYN. But it's become much more controversial as it's spread, right? And now we're talking about pharmacists, and we're talking about nurses and anesthesia assistants, and any medical procedure that an individual health provider objects to, whether or not it's abortion. And there's a set of Bush regs that were just promulgated that Obama says he's going to take back. And there's just been a decision of the Supreme Court of California about a doc who didn't want to do some sort of high-tech fertility treatment for a lesbian couple, so one partner in a couple who conceive. So it's a hot issue right now, and there's no generally accepted solution to it. Here's my view. The healthcare provider should generally have the right of conscience objection, generally have the right not to perform these procedures, but not if they occupy a blocking position. If you're the only OBGYN for miles and miles around, then you may have to do them, and if you don't want to do them, you may have to move to a bigger city where there are alternatives. The pharmacist who says, I don't want to fill the prescription is one thing. The pharmacist who says, and I won't tell you anyone who will, is a different thing. And the pharmacist who looks at the prescription and tears it up, and there's been at least some reported cases of that, is plainly a different thing, right? So these questions generate difficult balancing questions. So you clearly got a right of the patient who's entitled to the service, and a real crisis of conscience for the healthcare providers being asked to provide it. And I guess my view is the inconvenience of going to the next doctor is not a compelling interest. It ought to require the objecting doctor to override his conscience, but doing without the service is, and nobody should be able to position themselves to deprive others of the service. And in some of the cases, the service is needed on an emergency basis, which also makes the case more difficult, and there isn't much time to go to another provider, and there certainly isn't time to go around from place to place asking around to try to find the one person who will do it.
I think we're out of time. I just want to, on your behalf, to thank Doug for his wisdom and for sharing it with us. I'm very grateful. Thank you.
Fun. Sorry, what case? Warner versus City of Boca Raton. It's a horrendous opinion. It just rips the guts out of the Florida.